Hello, my name is Ethan Scrima, and I'm going to be talking about civil law in Louisiana. So, civil law is also known as Napoleonic law in the US. It differs from English common law in that it attempts to interpret the intent of legislation looking at the facts of each individual case, whereas English common law attempts to look at the previous history of cases similar to the one that the judge is looking at currently, and it uses the concept of precedent in order to come to a decision. Most European countries use civil law rather than English common law, with the exception, of course, of the UK. And the US, 49 out of 50 states use English common law, obviously as a result of English influences due to being a colony of Britain. However, Louisiana is the only state in the US that does not use English common law and instead uses civil law. So how did this come about? Well, Louisiana was, of course, part of New France, which was France's colonies in the New World. Louisiana was heavily influenced by French and Spanish legal concepts, as it was owned by both of those empires at some point. The territory was then purchased by the US in the Louisiana Purchase, by Thomas Jefferson, and the legal systems were heavily influenced similarly to the Napoleonic codes. The Louisiana civil law system was not influenced directly by the Napoleonic codes, as the codes came later than the original Louisiana legal system. However, they were influenced by the same type of thing. So, some of the inputs that affected Louisiana's adoption of civil law were due to its history as a French and Spanish colony. So in 1664, the custom of Paris was adopted as law. This was the law that was, or the legal system that was adopted in the area surrounding Paris. This was due to various royal ordinances and the charter that was issued to the French East India Company as well. Then, after the Spanish Cession of 1773, the Recuperación de las Indias and the Siete Partidas were adopted as law. These were legal codes that originated in Spain. The Digest of 1808 happened after Louisiana became a U.S. state. They were attempting to reconcile the Spanish and French foundations of the Louisiana law with the United States' law. And the digest was created by a few lawyers named Edward Livingston, James Brown, and Louis Moreau Laillette. Um, there was a court case called Cotton v. Cotton, in which it was found that the digest of 1808 was invalid because the Recuperación de las Indias and the Siete Partidas had not actually been repealed, and it was found that the Digest of 1808 was not valid law in Louisiana because of that. The Louisiana legislature ended up commissioning the Civil Code of 1825, which attempted to reconcile the old Spanish law systems with the Digest of 1808. And as I said before, the Civil Code of 1825 was not directly derived from the Napoleonic Code. However, they did share the same influences, namely the custom of Paris. So some of the institutions that caused this to come about were obviously the colonial governments of France and Spain. They were the ones who adopted these systems of law in their Louisiana colony. The Louisiana Supreme Court then was the institution that upheld the civil law prescription rather than changing over to common law, and they were also the ones that were attempting to reconcile the French and Spanish original legal concepts with those of the new American country. And the Louisiana legislature also did play a major role in this, as they were the ones who actually commissioned the new law code in 1825. So my two questions are, is Napoleonic law better than common law? And should Louisiana standardize its legal system with the rest of the US? And here are my works cited.